Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. Thank you for joining us for this post-decision episode of SCOTUScast, Double Jeopardy Edition. I'm your host, Christopher Goffis. On November 29, 2016, the Supreme Court decided Bravo-Fernandez v. United States. A jury convicted petitioners Juan Bravo-Fernandez and Hector Martínez-Maldonado of bribery in violation of 18 U.S.C. Section 666, but acquitted them of conspiring to violate Section 666 and traveling in interstate commerce to violate Section 666. The jury's verdicts were therefore irreconcilably inconsistent, and the petitioners' convictions were later vacated on appeal because of an error in the judge's instructions unrelated to this inconsistency. On remand, Bravo and Martinez moved for judgments of acquittal on the standalone Section 666 charges, arguing that the issue preclusion component of the Double Jeopardy Clause barred the government from retrying them on those charges. The district court denied the motions, and the First Circuit affirmed. The question before the Supreme Court was whether the eventual invalidation of petitioners' Section 666 convictions undermined the United States v. Powell instruction that issue preclusion does not apply when the same jury returns logically inconsistent verdicts. By a vote of 8-0, the Supreme Court affirmed the judgment of the First Circuit. In an opinion by Justice Ginsburg, the court held that the issue preclusion component of the Double Jeopardy Clause, which bars a second contest of an issue of fact or law raised and necessarily resolved by a prior judgment, does not bar the government from retrying defendants after a jury has returned irreconcilably inconsistent verdicts of conviction and acquittal, and the convictions are later vacated for legal error unrelated to the inconsistency. Justice Thomas filed a concurring opinion. And now, to discuss the case, we have Paul Crane, who is Assistant Professor of Law at the University of Richmond School of Law.
So this case is about the Double Jeopardy Clause of the Fifth Amendment of the Constitution, and in particular, it's about something called the issue preclusion component of the Double Jeopardy Clause. So the Double Jeopardy Clause of the Fifth Amendment provides, quoting from the text here, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." And the basic purpose of the Double Jeopardy Clause is to protect against successive prosecutions by the government. So if the defendant was acquitted of an offense, say bank robbery, what the Double Jeopardy Clause, the core of it, the heart of it is getting at, is preventing the government from saying, all right, well, you're acquitted, but let's try that again and again and again, and keep running it back until they get a conviction, sort of ensuring that the government can't keep prosecuting someone for the same offense until they get the result they want. The issue preclusion component of the Double Jeopardy Clause has a similar purpose, but the way it acts is a little different. And what the issue preclusion component is getting at, and again, that's what the Bravo-Fernandez case is about when a jury has decided an issue of ultimate fact, that decision has binding preclusive effect going forward, and therefore limits and prohibits the government from, again, taking successive bites at the apple. The issue preclusion component is limited to those issues, and this language will be important in a minute for reasons you'll hopefully see, to issues that are necessarily decided by the jury. Now, the court first recognized this issue preclusion component of the Double Jeopardy Clause in a case called Ash versus Swenson. And because the facts there sort of nicely illustrate the protections the issue preclusion rule are trying to provide, let me briefly explain what was happening there, and then we'll talk about Bravo-Fernandez. So in Ash, there were 6 poker players who were robbed, and allegedly Ash was one of the robbers. Government prosecutes Ash for the robbery of poker player number 1, and that prosecution results in a not guilty verdict, an acquittal. The only issue in dispute between the parties in that first prosecution was the identity of the robbers and whether Ash was one of the robbers. So the jury necessarily decided in that first case, Ash is not one of the robbers. The government comes back, second prosecution involving a different poker player, basically saying we've learned from our mistakes, we're going to put forth a better case this time around, and gets a conviction of Ash. And Ash complains to the court that this violates the issue preclusion component of the Double Jeopardy Clause because in the first case involving the first poker player, Ash says, look, the jury there said I was not the robber. I was not one of the robbers. I was found not guilty. The government can't keep coming back and sharpening its case over and over until it gets the conviction for this set of conduct that it wants. And the court and Ash agrees and says the acquittal in that first case, the jury must have decided that Ash was not one of the robbers. That determination of fact carries forward in future cases between Ash and the government. Basically says, government, you're not getting 6 bites at the apple here. Ash, not guilty, cannot prosecute in future robbery. You can't do future robbery prosecutions from this series of events. So Ash is the first time the court recognized this issue preclusion component of the Double Jeopardy Clause, and it's another way of trying to limit the government's ability to prosecute multiple times against a particular defendant. To understand the question presented in Bravo-Fernandez, helpful to understand 2 more prior precedents, basically of which the case turns on. That's United States versus Powell and Yeager versus United States. Those 2 cases and the Bravo-Fernandez case are really all about what should we do when the jury acts irrationally, the jury's gone wild situation. So in Powell, that case involved a situation where the jury returned both a guilty verdict and a not guilty verdict on counts that turned on the same issue of ultimate fact. In other words, the jury's verdicts were irreconcilable. A rational jury, following its instructions, should have either found guilty on both or not guilty on both. And the question in Powell was, does the not guilty verdict have preclusive effect? Does the issue preclusion rule apply? And the court said, no, it doesn't. We don't know what the jury necessarily decided. We know the jury was irrational, it acted and with irreconcilable verdicts. A rational jury should have either done both guilty or both not guilty. We don't know what they were deciding on the issue of ultimate fact that both counts turned on. That means no preclusive effect, both verdicts stand. The guilty verdict stands, the not guilty verdict stands. All right, that's one sort of end of the spectrum. Yeager, the second case that Bravo-Fernandez, the parties are fighting about, the case turns on, involved a situation where the jury returns a not guilty verdict on one count and hangs on the other count. So it does not return a verdict. It remains silent on the second count, where, again, the counts turned on the same issue of ultimate fact. So, again, a rational jury, following its instructions, should have returned guilty on both or not guilty on both. In that sense, the jury's actions, just like in Powell, are irreconcilable. It should have been guilty on both, not guilty on both. But that's not what the jury did. It said, not guilty on one, we can't reach a decision on the other. And in Yeager, the Supreme Court says, in that context, the acquittal does have preclusive effect. So the acquittal stands, and the count on which the jury hung is now a count that the government can no longer prosecute. It can no longer pursue. It can't do a retrial on the count on which it was hung. And the rationale behind that was, the court says, well, when a jury hangs, that's a non-event. There is no decision it's making. The only decision the jury made is an acquittal. And in that sense, Yeager looks very much like Ash. We have an acquittal. We know what the jury must have been thought about the issue of ultimate fact. That has preclusive effect going forward. All right, that gets us to Bravo-Fernandez. Now, Bravo-Fernandez and his co-defendant, as relevant to our discussion, were charged with 3 separate offenses related to allegations that Bravo-Fernandez bribed a Puerto Rican official, the co-defendant in this case, in exchange for legislative favors. And the nature of the bribe, though not particularly relevant for the ultimate double jeopardy question, involved providing that official with an all-expenses-paid trip to Las Vegas, including tickets to a boxing match there. So apparently what happens in Vegas doesn't always stay in Vegas. Now, Bravo-Fernandez and his co-defendant were charged with 3 offenses that matter here. 1, bribery and violation of 18 U.S.C. Section 666. We all know bribery is the devil's work. I'm just kidding. It's a coincidence that bribery is Section 666. All right, that's count 1, Section 666, bribery. 2, conspiracy to violate Section 666. And 3, traveling in interstate commerce to further violations of Section 666 in violation of something called the Travel Act. Basically, the case revolved around, was there a bribe or not? Which means the jury, if it was acting rationally, should either find, yes, there was a bribe, and therefore guilty on all 3 counts, or no, there was not a bribe, not guilty on all 3 counts. The only issue and dispute between the parties was whether there was a bribe. So what did the jury do in this case? Well, after a trial, it did neither of those things, and instead was another jury gone wild. The jury in Bravo-Fernandez's case found the defendants guilty on bribery, for that first count, and acquitted, not guilty verdicts, on counts 2 and 3, conspiracy and the travel count. So this is another situation of irreconcilable verdicts. No rational jury should have returned such a split verdict. If the case had ended there, it looks just like Powell. All the verdicts stand. But the case did not end there. The defendants appealed their bribery conviction, and the First Circuit vacated for legal error related to the jury instruction. So as the case got up to the Supreme Court, there was not guilty verdicts on conspiracy and travel, and they vacated guilty verdict on bribery. And the defendants, Bravo-Fernandez, say, well, that looks like Yeager to us. That looks not any different than a hung jury count, and therefore the acquittals should have preclusive effect, and the government should not be allowed to retry us on the bribery charge. And that's the question in Bravo-Fernandez. Can the government retry the defendants on the bribery charge, or does the not guilty verdicts on conspiracy and travel have preclusive effect prohibiting the government? What do you do with these types of irreconcilable verdicts? The jury found guilty and not guilty. The guilty verdict is later wiped out. Well, the court holds in a unanimous opinion written by Justice Ginsburg. This is when it was still an 8-member court at the beginning of the term. 8-0 opinion saying that this case looks more like Powell, not like Yeager, and the acquittals do not have preclusive effect. There is no issue preclusion here, which means the government can re-prosecute on the bribery count. And its rationale goes a little something like this. The whole point of the issue preclusion component is to try and figure out what was the jury doing. What did the jury decide? And unlike Yeager, where the court said, with hung juries, we don't know what that hung jury resolution meant. The jury didn't decide anything. That's not true here. The jury found guilty on the bribery count. And so when we look at that, we don't know. We can't say confidently that the jury did or did not think a bribe occurred. Its verdicts make no sense together. They're irreconcilable, they're irrational, and therefore we don't know what the jury ultimately decided. It's just like Powell. Therefore, there's no issue preclusion from the not guilty count. Yes, it's true. The court acknowledges that the conviction was later vacated, but that just means the conviction's vacated. That doesn't mean we still can't learn what the jury was thinking or not thinking. that it's still the jury returning a guilty verdict provides a window into what it was possibly deciding. The court also sort of emphasizes that the issue preclusion doctrine is one where the party requesting preclusive effect bears the burden. So here, Bravo-Fernandez and his co-defendant had the burden to show that the jury necessarily decided there was no bribe. And Bravo-Fernandez can't make that showing, the court says, because the jury found him guilty of bribery. Finally, the court notes, sort of going forward, which could be potentially relevant for similar factual scenarios, where an appellate vacator of a conviction could unlock the preclusive effect of an acquittal in two situations, neither present here. One, if the vacator is based on insufficient evidence, as opposed to legal error, because that means the jury should have returned an acquittal. There was not enough facts to support a conviction, and in that sense, the conviction disappears. It's wiped away. It looks like Jaeger. The second situation is if the legal error makes the verdicts reconcilable in some way. If you could reconcile the verdicts in some way, and the acquittal could have preclusive effect because you would necessarily know what the jury decided. And that's, in either of those situations, the rule from Ashe, the issue preclusion component, would have application. But that was not the situation here. Justice Thomas wrote a short concurring opinion, renewing his doubts about there being an issue preclusion component of the Double Jeopardy Clause at all, and says the court should at some appropriate time reconsider the doctrine as a whole and reconsider Ashe, but concurs because he agrees with the conclusion here. In terms of the significance going forward of the opinion, the significance seems to be more about the opportunity declined by the court. The resolution it reached, and maybe indicative of the 8-0 nature of the opinion, is pretty consistent with prior precedent. If the court had gone the other way, if it had found in favor of Bravo-Fernandez, well, that would have signaled a real shift about not only the expansive reach of the issue preclusion component of the Double Jeopardy Clause, but the reach of the Double Jeopardy Clause more generally. But the court declined that opportunity and issued opinion pretty consistent with existing precedent. And in that sense, this seems more just maintaining the status quo, and the notion that the court might be using the Double Jeopardy Clause in a more expansive way than it has previously, if it's going to do that, that time has not yet arrived. One last bit of trivia and wrap up. This was the first opinion issued by the court of the October 2016 term. Not a coincidence that it was unanimous, and also probably not a coincidence that it was Justice Ginsburg issuing the opinion, as she is known for her expeditious opinion writing.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.